Further ado, I would ask Wojciech for his first intervention.
Thank you, Radim. Good morning, everyone. Indeed, I represent here European Commission and what we do on the digitalization, but please bear in mind, because I know that presumption is that we in Brussels will live in a kind of a bubble, not being aware what's happening on the ground, and our policies sometimes are detached from the reality and real needs. But please bear in mind that there are many of us within the Commission that do come from the ground, and me myself, I'm a judge working for years in the Polish judiciary, then doing a lot on training, and now since some years in the European Commission. Maybe saying that, I think that I would be better fit for yesterday's panel on extrajudicial activities. But I'm here because I'm working for the unit that's named Digital Transition and Judicial Training. These two topics were put together. I'm heading the second one, the part on judicial training. And in my presentation, I will try to explain where's the link between the two. And I was tasked for today, for this panel, to share with you what are the Commission works now on the digitalization of justice. What we have in the pipeline, what kind of projects, what kind of initiatives of diverse nature we are putting in place to maybe set it as a scene to discuss how that can impact the diverse national systems of judicial governance, all those things that will be coming down from Brussels. And in my presentation, I will mention three elements because we are trying to limit our legislative production. We've used to produce a lot of law. I won't comment on it, but now this Commission, according to our President and her second term, this is the Commission, this is to be a Commission on focusing on implementation and enforcement, much more than on the production of the new law. That's why I'll start with saying about this strategy that we are now drafting. The working title is Digital Justice in 2030. This is the strategy that is putting together diverse tools and solutions of non-legislative nature. Then, of course, there is a big digitalization legislative package that you know, regulation and directive adopted 2 years ago, that is digitalizing cross-border collaboration. And at the end, in the last few minutes, I will mention what the training of judges has to do with it all. But let me start with mentioning three, not principles, but three ideas that are underpinning whatever we do on digitalization. It was said already yesterday that we don't push for digitalization for the sake of having digitalization because it's fancy, it's topical, it's here. As you said, it's not a new topic. It exists since years. AI, the very name, exists since the 50s of last century, as we know. So there's nothing new. That is the new circumstances that forced us to use it more. So we don't push for digitalization for the sake of it, but to contribute with it to building the efficient and quality justice. That's the purpose. We believe that the digital tools, digital solutions might help to build efficient and quality justice. Why? Again, there's a further reason for that, because the effective justice is a condition for the economic growth. And it's the obvious thing, it improves the competitiveness of European economy, resilience of European economy, so much needed now these days. And we all know that from the conclusions of the Council of the April last year, when all the member states agreed that the competitiveness and European competitiveness deal will be in the center of the work of all institutions, not only the Commission, all EU institutions for the years to come, definitely for this mandate of the European Commission. Further, of course, digitalization is not only to make system efficient, so fast, but also open for citizens and businesses. So we believe that digitalization, if properly run, can increase, not defer, can increase the access to justice. And finally, the last element that is for us the starting point for thinking what and how to do is that while we try to harvest all these efficiency gains of the digitalization of justice, we have to identify and mitigate potential risks. We cannot be over-optimistic. We have to be aware about the dark side that is coming with it. So we have to ensure that there is a security and protection of the fundamental rights, as enshrined in the EU Charter, and the safeguards against the inequalities, discrimination, or exclusion digital exclusion is here around of anyone. So this is the foundation on which we build both the legislative and non-legislative solutions. What is the strategy? First point, 2030. So last year we started to work on it. The work was based on consultations with many justice stakeholders. We were presenting our ideas, they were telling us what they think about it. And it led us to create a kind of a draft of the strategy that this year we'll be discussing with the member states, with the governments. And we've identified 4, 5, 5th is a bit of non and legislative mixture, the work streams of this strategy that we want to promote and encourage member states to work on. And a few sentences about each of them. So the first work stream, our idea is to force member states to be more open to exchange their best practices. So our idea is to create a kind of living depository of the solutions, how and who already managed to digitalize their national justice system, whatever is meant under that. And the objective for this work stream is to allow other member states that might be somehow lagging behind to be inspired, to possibly see what worked, what did not work, which processes worked, which did not, which solutions are effective, which are not to do the same mistake, not to reinvent the wheel. Second work stream is about the AI. AI Act, everyone is talking about it now. Last year, the Commission created its own AI office, as you might know. And this AI office is to put the AI Act into practice. One of the things that our colleagues in AI office work on is the guidance how to understand and handle the high-risk AI systems. This guidance is to be published in February 26, so in a year. It will be addressing all the challenges that are coming from the AI that has this potential of being of a high risk. So there's a risk of making it discriminatory, creating inequalities, jeopardizing the fundamental rights. And of course, we expect that most of the AI systems that are thought to be in the future used in the justice system will be high risk. So this guidance that will come from AI Office, that we work together, we as DG Justice with AI Office on this fraction of their work. So the high-risk AI system in justice will be of help, we believe, to all member states to handle the AI system storming into the courts, and not only. The third work stream, I cannot forget pushing this one. The third work stream is the IT toolbox. It's something else than the first one. First one is just a depository of who does what and how, what were the mistakes, just to get inspiration and awareness what's happening. The second one, we are called by the Council to create it. It is to be a toolbox of the tools that were developed by member states, or by us, by the Commission with our funds, and can be used, just taken and implemented in another member states for free or under some fees. It will be dependent on the member states that will be putting their stuff in the toolbox. So not only to get inspired, workstream 1, but to get something ready-made that fits the needs of another member state, another system. So this toolbox is the third workstream that we'll be describing in detail in the strategy. The next one, European legal data space. What does it mean? Already now, we talk a lot about the need to systematically collect and provide the access to the EU law and national law and EU and national case law related to the EU law. And we believe that the digital tools, AI tools, might help, firstly, to make it really working with the automation of the anonymization, with the automation of the translation, with the better search engines, etc. Such databases can be of great benefit, both for the practitioners, judges, lawyers, etc., and as well for the general public, if interested in the law and the EU case law. But the second aim of creating this kind of the legal data space, which will be much more sensitive, I'm aware, would be to use it to train and develop AI. To train and develop AI tools for the use in justice. So when we have such a rich database of EU law, and more importantly of jurisprudence on EU law coming from all courts, national and European courts, that would be the great ground to create and train AI tools. okay, with all the awareness of the risks that are coming here. And the fifth element of the digital strategy will be digitization of the court proceedings, simple things, technical things, like, for example, we'll be proposing having the common technical standards for the procurements of video conferencing to secure that everything that we have in our member states is compatible, that our system can talk to each other. As we spend so much, let's think about the next steps, and all the spending is to produce some kind of interoperability of our systems. So that's in short what we plan to have in our digital justice strategy. What will be the next step after these consultations of stakeholders that produced this list? This year we are launching so-called high-level forum on justice for growth, where we'll be discussing with the representatives of the member states all these solutions, to what extent they are willing, eager, available to share, to commit, to work on these tools, because we as a Commission, we can do nothing on any of these work streams without the member states. And we do only those things that are of help for the member states. We don't do it for ourselves, for the success of the Commission, somewhere there in the Brussels. So we start with the conference under the Polish presidency in May, and then will be 5 big meetings with the member states till the end of the year. And at the end of the year, we aim to publish the Digital Justice at 2030 strategy. But I said, Commission would not be a Commission if it was not producing a law. So I guess you know that in the 23 two instruments, regulation and directive were adopted. They came in force in January last year, and they are digitalizing judicial cross-border collaboration in civil, criminal and commercial matters. Also with the aim to improve, enhance this cooperation, to decrease the costs of the cross-border proceedings, to reduce the administrative burden of these proceedings, to improve access to these proceedings. These are the objectives. But what exactly this regulation and directive is saying, that till 2031, so over the next 6 years, all those instruments that you see on the screen, 24 instruments of cross-border collaboration, will be used in digital space. So the national authorities will be communicating digitally when applying all these instruments. So substantially, instruments will stay as they are, but the way of using them will be digital. Sounds simple, but you can imagine what it will mean in practice. To have the tools, to have the instruments, to have the professionals capable of applying them. There will be something like European Electronic Access Point, one-stop shop with the access to all these instruments. And this, it will mean that over the 6 years, we will publish 26 implementing instruments, each digitalized cross-border instrument, explaining what, how, what kind of technical specificities the tool has to have. And here on the screen is the detail. I won't be reading it out. I hope this presentation will be sent around after. If you're interested, you can see which instruments will be digitalized in which of the batches that we divided it all into. So what will be happening in the course from today? We start from May 25 on service of document and taking of evidence in cross-border cases till 2029, when the last instruments and the cross-border cooperation will be digitalized. So that's the second direction of our work, and we as DG Just will be devoting a lot of energy, of course, into producing all this. And the third strength is the judicial training. What judicial training has to do with it? Someone can ask. Of course, as you saw, all those legislative and non-legislative solutions that the Commission will be proposing can create a lot of challenges, a lot of tensions between different actors. Different actors will be involved: the ministries, the councils, the presence of the courts, and the judges themselves. And we believe that nothing can happen without the judges. So judges should not be just a passive recipients awaiting. There's something coming from Brussels or from my capital or from somewhere, the instrument, then I have a look. Is it for me? Does it fit me? No. Judges should be involved from the very beginning in design, development of those instruments, and be mentally prepared to use them at the time when it's coming. And they should be aware when they are coming. That's why, in parallel to the Digital Justice 2030 strategy, we work on the new judicial training strategy. It is planned for the adoption for December this year. and will be in force from 26 till 2030. And it will have two features. It will have a strong focus on digitalization. Till now, under the strategy, we support, including financially, different topics, different events, like this project, like this event. Now, the next strategy will have a strong focus on digitalization. It will be very narrowed. Because the digitalization must be supported by the training. That is to become the supportive environment, as we call it, for judicial training. Why? There's not enough training. Here you see the statistics of the last year. There's a bit of on IT skills, more for the court staff than for the judiciary. But judicial training on digitalization, on AI, is limited. You can see the percentage on the screen. So there's a lot to be done. The overall objective will be to build digital capacity, AI literacy of the justice professionals. What does it mean in practice? We'll be investing in the skills of justice professionals, understood broadly, not only the skill how to use the keyboard for the new system, but you can imagine video conferencing. We talked about communication. We trained judges for years on how to communicate in the courtroom. Now new chapter, how to communicate via the camera. It's a different thing. How to assess credibility of a face on the screen, not on the person with all the body language in the courtroom. We know what it means for the judges. We call it e-judge craft, so the craft of judging in the e-space. So all these kind of skills are a very, very broad topic. Secondly, knowledge. Knowledge about the substantive law that is adapted because of the EU law, because of the national law, adapted to the needs of digital economy and society. And awareness. We have to build the awareness of the judges, of all justice professionals, about the potential on digitalization, about the risks, about the AI, what it brings with itself. So that is the third pillar of the work of the European Commission on the digitalization in the years to come. And my last slide is referring to the awareness. I know if you can see. This is the one of the slides summarizing the conference we had in Brussels last April 2024 with justice stakeholders about digitalization. We were then discussing with them how training should assist digitalization. We were asking about the feelings. What judges, prosecutors and lawyers think about this wave of digitalization. And you can see what is the percentage feeling fear, where is the enthusiasm, 25, and the lower figure is 25. The enthusiasm is at 25. The highest is still positive attitude, 73. But my last sentence is that discussion shown that it's very easy to move from one feeling to another. That many judges, being enthusiastically approaching digitalization, once they start to use some tool that is landing on their desks, are becoming frustrated because they were not involved, they don't know how to use it, they don't know what it is. So that's the role of judicial training to avoid such moves of moods. Thank you.
Thank you. Thank you very much. This was perfect overview, and this I just can't help myself, but probably that graphic representation, it would not be proper if we would run this poll around here, then probably it would end up in a different way. But this frustration and enthusiasm and things, maybe there are people who are enthusiastically frustrated. and what I see in our judiciary is also frustrated enthusiasm, or enthusiasm that turns into frustration. So these categories sometimes can be very close. And I would just add to what was said, these data spaces, that's a general strategy of the European Commission. We'll have data spaces in many other fields. And that is the